Welcome to the Hot Law Podcast, where we discuss the hot topics in today's news from the legal perspective. This podcast is brought to you by the Beaulieu Law Firm, PC. This podcast is not legal advice and is strictly for educational and entertainment purposes. For legal advice, visit the contact page at www.beaulieu.firm.com.
Yes, and welcome to the Hot Law Podcast, Episode 1. Brought to you by the Beaulieu Law Firm, my law firm. So glad you could join us today for our very first episode. And it's a very special episode because it's a double header. We have a part 1 and part 2. Part 1, we will be discussing fashion law, and part 2 will be discussing sports law. Why are we doing a double header? Because next Thursday, September 6th, is the beginning of New York Fashion Week and the NFL regular season. So it's going to be a fantastic show. We have some great guests here. And we're going to be starting off with fashion show, and our second part 2 episode will be sports law, and you can check that out. There'll be separate links for it, but it's all part of episode 1. So let's start off with fashion show. And we have our guest here, John Pirro. Introduce yourself and tell everybody why you're so awesome, because I think you're awesome.
I appreciate that. The feeling is mutual. So let's enjoy each other's company for the next 35, 40 minutes. So my name is John Pirro. I am a shareholder in an 18-attorney firm, boutique firm that focuses exclusively in intellectual property law. My particular practice relates to trademark law, copyright law, trade dress law, and I will help you register and protect your rights in the U.S. or all around the world. I will help you enforce as necessary or defend if you're accused of anything. And I have 2 particular focuses. One is a fair amount of work in fashion, and also a particular interest in, cannabis law, as that's developing very, very rapidly and has some unique intellectual property law issues. And my firm also handles patent matters, though I don't do that specifically. So anything under the IP law umbrella, Gottlieb, Rackman, and Reisman.
All right, fantastic. Thanks for joining the show. I really appreciate it. Now, let's talk about a little bit about fashion law. Now, what is fashion law? Now, it's a bit of a misnomer. There is no general fashion legislation or fashion statutes or really general fashion legal laws. Now, quite a few fashionistas and fashion experts will argue differently in terms of breaking the rules of fashion, but that's merely, fashion faux pas. But what fashion law generally is, it's just the basic legal application to the fashion industry. One of which is intellectual property. In fashion, it's all about the designs, it's all about the brands, it's all about creativity, which is all intangible intellectual property and work. And now generally that kind of intellectual property is placed on garments and stuff like that. But it's still intellectual property, still intangible. It's all about the designs and brands. But how can you protect yourself? Because there are a lot of copycats out there. Say if you have a really hot brand, a really hot product out there, there's generally going to be copycats that's going to try to capitalize on your success and, really cutting off your income and revenue streams. So, John, how does one generally protect themselves from that kind of incident?
Okay, so let me start by just giving a very, very brief intro to the different types of IP, right? Because the different types of IP will protect different things like a brand or a design. So let's start off with trademarks. Trademarks are, quote unquote, source indicators. Trademarks are brands. Trademarks are logos. Anything that lets you know, right, that a product or comes from a specific source can function as a trademark. So Nike, the name, the Nike swoosh logo is a different type of trademark. But trademarks get into more unconventional things, which we're going to talk about in relation to a specific case later. Can be colors. The NBC chimes, boom, boom, boom. That's an actual registered trademark with the United States Patent and Trademark Office. Then there is patents, and patents fall into a couple different categories. Patents include, what people typically think of with patents, which are utility patents, and those will protect a novel invention. A method could be patented with a utility patent. Then lesser known, but very, very important recently, are design patents. You could protect the design of a product. Design patents got a lot more publicity and press, kind of blew up in the public consciousness because they were one of the important parts of the Apple versus Samsung decisions. The $1 billion reward that Apple got was mostly with respect to some alleged infringements of their design patents. And lesser known than that is their plant patents, which are very relevant for the cannabis industry, but not really relevant for fashion.
Just plant patents.
Yes, and then copyright law. So people think of copyright law, you're really protecting any creative output. So people typically will think of copyright law protecting a movie or music. But copyright law can actually protect other things that are lesser known, like all of the stuff on a website. Or in particular reference to fashion, design. So a floral design that appears on a dress, that could be copyrighted. And then the last kind of general field in IP law is trade secrets. So there's certain things that don't fall into the other boxes that are still very important to protect. And so really what you do is you treat them consistently as a secret. These are things that you don't want an employee on the way out the door, to steal.
Oh, for sure.
And so my favorite example is Colonel Sanders' blend of 11 herbs and spices, which I used to be more familiar with before my wife cracked down on that. I still, anytime we drive by a KFC, I just go, ooh, the Colonel. And then we keep on driving.
Yeah, for sure. Smells good, man. Smells good.
Yes.
Love me some chicken.
So let's now talk about how the fields of IP, relate to specific parts of the fashion industry. So obviously, anything, in terms of the brands, the names of the designer, that falls under trademark law, and you want to protect that. And fashion particularly, there's a pretty big common practice of naming your brand with your own name. And just trying to build up your own name, which actually gets very interesting because certain designers start out under someone else's company and they build up their own name. And sometimes when they start out, I can't think of an example off the top of my head, they start out at a larger brand and, like a Prada or something, they build up a name and then they might, because of their employment agreement with that larger company, not own the rights to their name when they leave. So something like that happens.
The work for hire, right?
Yes, like different types of work for hire, and these could be very, very, restrictive agreements.
Right.
So those are trademarks. Copyright, like I said, is actually very important for fashion because you can't protect typically. It's difficult to protect like the shape of certain, like a specific dress to protect it, but you can protect designs on them. And just because of the way that the copyright system is currently constructed, it's kind of created this cottage industry of what a lot of people call copyright trolls. So you could protect a design on, a dress. So I create a nice floral design. I could immediately send that into the Copyright Office and I could register that. You can't go on to the Copyright Office and see what's been registered. There's just too much there. The system's not set up that way.
Right.
So you could go out and, certain people go to, it was a very common industry practice to go to China, to go to these mills and buy garments there and bring them back and sell them to different retailers. What happened is that there ended up being a ton of copyright infringement lawsuits by a couple of specific companies in California mostly, where they sued and said, you're infringing my garment. And the one thing about copyright law is if you register it early, if you register it before you first release something, if you register it before you see an infringement, if you register it quickly after you first release it, there are very, very nasty damages built into the Copyright Act itself. Right, statutory damages. So for one infringement, you might, as an alleged infringer, make a couple $100 in profit, but they could tag you for up to $30,000 under the statute and get attorney's fees, which is even scarier.
Yeah.
And if they have any evidence whatsoever that it's a willful infringement, that could increase the maximum statutory damages to $150,000 per infringement. And attorney's fees, which is going to be just as scary and just as much as $150,000 if you're talking about a litigation.
No, for sure.
So I actually spend a fair amount of my practice defending against those type of lawsuits. And so that is something that's had a very, very large effect on certain segments of the fashion industry. It's, changed kind of best practices at a lot of companies, and it's incentivized, having in-house designers rather than going, and buying something that when you come back could be alleged to infringe. Patents aren't, utility patents aren't so applicable to the fashion industry but design patents certainly are. Design patents you could get on the specific shape of a shoe. I think sometimes you can get even on a distinctive shape of a dress. But no matter what the type of IP law is, there's kind of a central concept that runs through it and is very important for the fashion industry, because generally articles of clothing or fashion aren't just ornamental, they serve a function. So the kind of common concept between the different fields of IP law is that you can't protect the functional aspects of something. You could really only protect the aspects of it that are ornamental, that really contribute to the appearance but don't affect the function. So there was a very famous case with the Supreme Court, I believe, or maybe it was a Court of Appeals, relating to a belt, right? And they could not, the designer tried to protect the entire, I think, design of the belt, but what ended up happening was that the only protection, I think, under copyright law was to protect the aspects of the buckle itself that were not functional. And so that's kind of a common thread throughout all the different types of IP law, and is very, very relevant to fashion industry in particular. Our firm actually has a bit of a specific expertise in dealing with, the fashion industry in general, and also getting some of these types of protection for different fashion garments. I mean, we were able to obtain trademark registrations on the product configuration of some very, very famous pieces of furniture, actually.
Yeah.
So the Barcelona furniture designed by Mies van der Rohe, we got trademark protection for the actual design of the different pieces, which is a remarkably effective tool for enforcement, for one thing, because trademark registration could go on in perpetuity.
Right.
If you continue using it, you could continue filing documents with the U.S. Patent and Trademark Office and have protection forever.
But that's different when it comes to copyright.
Copyright is nice, long protection. It depends upon whether the owner is a corporation or an individual. And the interesting thing is that the length of that protection keeps on changing and getting longer, because they're very powerful companies, specifically Disney, that don't want the earliest incarnations of Mickey Mouse to go into the public domain.
Right. So
they'll consistently lobby. And at this point, you're looking, at minimum 70 years of protection, which is very nice. And typically, most of your value is going to be towards the front end of that. But they'll continue to try to extend that as long as they can.
Now, you said something interesting in terms of copyrighting a design. Now, from my experience, mostly, I'm not as experienced IP attorney as you are, but isn't mostly designs a trademark kind of thing, or is it because
No. So there's certain trademarks. So when we talk about unconventional trademarks, right, we're going to talk about the Louboutin cases with the color red on the bottom of a shoe. We're going to talking about the NBC chimes, talking about the color brown owned by UPS. For any of these trademarks, whatever unconventional thing it is, you only get that trademark with respect to a specific set of goods and services. Just because UPS owns brown doesn't mean they could sue your infringement every time you go to the potty, right?
Yeah, that's right.
So it's really only specifically in relating to shipping, service, and packaging. And when you have the unconventional trademarks, there's a very high burden to meet to get the registration in the first place. You have to establish secondary meaning. Yeah. In other words, fame. So, for the registrations that we obtained for the Mies van der Rohe furniture, we had to include declarations from prominent people who work at different museums. You have to show a certain volume of sales. You have to show, sometimes survey evidence and so when we're talking about designs, there really are only a very few handful of designs that are trademarked. Burberry, the famous Burberry design, I'm pretty positive I've seen and dealt with that they have an actual trademark registration, but they had to establish secondary meaning to obtain it. Right. If it's a design on a garment, you are talking about copyright protection, which is very handy for the reasons I said in terms of enforcement. And, the one thing I'll say is there has to be a certain level of originality. It's pretty low, but if it's just a bunch of squares on a background, you're probably not getting that protection, right? Most of the time you submit an application, Copyright Office examiner looks at it and rubber stamps it if it just checks a couple boxes. And so, but there needs to be some originality there.
Well, one more question on the designs for copyright. So a design will be typically deemed a literary work.
I would say work of the visual arts.
Work of visual arts. Okay.
Yes.
All right.
Yeah, work of visual arts is where it would not fall under literary work. And ultimately, I mean, the way that you want to classify it properly, but ultimately the court will care about whether or not you have the registration or not.
Absolutely.
Not what box you checked when you filed it.
For sure. All right, well let's move on to our topic of the day, Christian Louboutin. It's New York Fashion Week on September 6th. So, John, who are you wearing today? Huh?
Who am I wearing?
Yeah, what you got on?
Nothing. I'm wearing Banana on Banana Republic.
Okay, no doubt about it.
Yeah, I got to save the money for the college fund for my 2 daughters.
Oh, okay. That's smart.
I like this color purple. You can't see it, listeners, but it's really flattering on me.
That's not bad. Brings out his eyes. All right. Well, we all know about Christian Louboutin. It's a famous brand, red bottoms. These is red bottom. These is bloody shoes. You know Cardi B, right, John?
Yes, I'm familiar.
What's your favorite song?
Oh, geez, off the top of my head, I don't know. Nothing's popping in my mind.
I don't put you on the spot there. Just
Yeah,
have
no
a
worries.
little fun. But yeah, so everybody recognizes the red bottoms. I mean, I don't wear high heels. You never catch me in those, but I know what they are. They're fabulous shoes. They're wonderful shoes. But for the longest time, they've been dealing with international legal battles regarding their red bottoms. So let's dive into it real quick. Just this year, the EU ruled in their favor. Christian Louboutin, they won a big legal battle on their long-running battle to protect their red bottoms. The European Court of Justice ruled that this Dutch company called Van Haren had infringed on the brand's trademark by selling a range of their own red bottoms. The case pretty much centered on the European trademark law that forbade registration of shapes where they add substantial values to good. But the court did note that Louis Vuitton was not necessarily seeking the shape of the shoe, but merely applying a color to the specific part of the shoe. So now that case is being remanded back to their lower courts, in which it is expected to bring validity to the Red Soul trademark. Now, in France, in the French case, the French Supreme Court confirmed a decision of their Court of Appeals, a lower court, which ruled that Louis Vuitton trademark was invalid. Their red bottoms was invalid because it lacked distinction, and there was no trademark protection and no trademark infringement by the defendant. It also rejected Louis Vuitton's unfair competition claim, stating in particular that Louis Vuitton could not claim a monopoly on the concept of having red soles on the bottom of women's shoes. And in Switzerland, Louis Vuitton argued that their red bottoms was original in a way that it labeled high heels, but the 5 judges of that court disagreed, and they saw it differently. They concluded that the coloring of the red soles was just a style, but it was not enough as a distinctive characteristic or something unusual to the customers. But when people see red bottoms, I don't care if it's another brand, they will automatically think Christian Louis Vuitton, if they spend years trying to protect themselves and market themselves differently. So, John, why do these courts look at the same things but come to very different conclusions?
What I'd say in general is that, a couple different factors. So the first is ultimately they're different arbiters, right? They're different judges looking at these cases, and these are ultimately, trademark law is at base very subjective. So it's unfortunate sometimes when I'm telling a client, okay, you're applying for a new mark, and there's some other marks out there on the registration already, and we draft an opinion letter and we say we can't tell you definitively whether or not an examining attorney is going to look at this and say that it's there's a likelihood of confusion or not. Actually, this prevailing standard in trademark law for relating to infringement is likelihood of confusion. It is rare that you're necessarily going to have evidence of actual confusion, right? And so likelihood of confusion is enough that you need to prove to say that something's an infringement and get someone to change, back off your mark, modify their mark, anything like that. So first thing I'd just say is different arbiters. 2, when you're fighting a war on this many fronts in this many jurisdictions, there's going to be different evidence that's admissible in every single one of those jurisdictions. The different arbiters are going to be looking at different materials. And materials, what evidence is submitted in these cases is very important, is dialing back to what I said earlier. For something like this that's an unconventional trademark, the fame is very, very important.
Mm-hmm.
And so, in trademark cases, a very typical type of evidence, when you're trying to determine if there's infringement or not, is people actually pay for surveys that could cost $100,000 to commission to see whether or not two parties will get confused or not. In a situation like this, it's, obviously, it's Louboutin or whatever, but in France, they're looking at different evidence that they're looking in the other EU court. And I also want to note, pretty importantly, that this also was a major case in the U.S. There was a lawsuit with Louboutin versus Yves Saint Laurent.
That's right.
It went to a decision in the Court of Appeals, Second Circuit, in 2016. And what ended up happening in that one is similar to the European Union Court, that they determined that it was protectable. So, that the red sole on a certain type, on a type of shoe was protectable. And so, that was a very, very, interesting case. I got a lot of analysis in my field. So I'd say the other thing, yes, is the evidence that they're looking at, the fact that it's ultimately a subjective determination. There's no clear-cut answers, and so you get different results in different places. And that's why when the stakes are high enough for protecting a trademark or for an Apple protecting a design patent where there are billions of dollars of sales, you will find, companies that are willing to invest large sums to fight these wars across different countries.
Right.
And you're going to have different results. You're not going to have the exact same result everywhere. And so it creates, these are international companies that could have the resources to fight these battles and then live out with the outcome as best as they can in different jurisdictions, treating it differently. So that's what I'd say, is that ultimately subjective, especially when you're looking at different evidence.
So what about a smaller client who comes to you who probably has a distinct product, but they don't have the budget to really fight these battles? Are they're just going to have to accept, what's going on out there with the copycats going on out there and copying their work and cutting into their income?
The way that I summarize my job really is that one of my main roles is being an educator. And so what I do is I educate my clients as to what the law is, in terms of the layout and how it affects things practically. And then the other phrase I say more often than not is cost-benefit analysis.
Yeah.
I educate you, business, starter, business owner, as to the lay of the land legally so that you can make the right cost-benefit analysis as to what level of protection suits you best. So sometimes if it's someone who's starting out, it's very difficult because when you're starting out, every penny counts. But the way that I kind of describe it is, for most companies out there these days, IP is their most valuable asset. And so, a penny spent now can save you $10,000 later.
Right.
If, an infringer comes along and you don't have adequate protection. If you are starting out, you don't have a ton of money to spend right now. But as soon as you're looking for investment, they're going to want to see that your IP ducks are in a row.
Right, for sure.
Because if you missed your opportunity to patent something because 1 year's passed since when you first closed it, there's no getting that back, right? And so that potentially is a gigantic loss of the value of your company because you didn't meet a deadline or weren't able to spend, a couple $1,000s for someone where you're now asking them for $1 million to invest. And so getting back to the question, yes, ultimately the merits of, the type of protection and what it could get you is important, and the budget is important.
Now, because here's another question, kind of piggyback off that. Now, say if they have a small budget, they'd be like, okay, so there's nothing we could do in terms of protecting internationally. But would they run the risk of losing their ability to protect their brand in the future internationally if they do nothing now?
So let's talk about trademarks specifically, because that gets interesting. And patent also, like I said, I'm not, a patent lawyer by practice on a daily basis. I'm not, patent barred. But in the U.S., trademark law, trademark rights flow through use. So even if you don't register but you're using a trademark. You're building up use that you could use to potentially enforce against someone. Registration gives you some very nice benefits on top of that make it, justify the cost of it. And so, sorry, I lost my train of thought. But so trademark rights flow through use. But here's the thing. The U.S. is different than most of the countries around the world, right? In most jurisdictions, you don't need use to file for a trademark. They're called first-to-file jurisdictions.
Okay.
So we encounter situations where, we start having some success in the U.S. and someone went and registered our mark in a foreign country. And then all of a sudden, you're growing to the point where you want to have a registration in that country. You're blocked by someone, who isn't really using. There are ways to cancel people who are essentially squatting on your mark. But you're talking about proceedings that could cost thousands of dollars. And you might need to wait if you want to have your best chance scenario, you might have to wait, past a couple of years where there would be a presumption of abandonment if they're not actually using it, they're just squatting.
Okay.
Patent, also there are time limitations that come into play. And so, yeah, cost is an issue. It's great if you had all the money in the world straight off the bat to just hop in and protect everything around the world. The vast majority of the time, that's not the case. And so you're doing some cost-benefit analysis. You're saying, all right, look, that's a good problem to have if I have to turn around and protect internationally, because that means I'm probably killing it in the U.S.
For sure.
And I'm looking to expand and I have more money to spend at that point to fight someone if they squatted on my stuff.
Okay, but as long as they keep it in use, they would have the legal means or the legal ability to protect themselves internationally or to enforce it internationally, rather.
No, I mean, it really, it comes use in each country is certainly helpful. Use is most important in the U.S. Right. Use is most important in the U.S. You have certain rights to enforce without a registration in the U.S.
Okay, great. All right, well, let's move on to another hot brand, which is Michael Jordan and the Jordan brand. Now, in my research, I was researching another case, but also fell into some of the Chinese intellectual property infringement a little bit, but you've dove into that a little bit more than I have. So let's start off with that as opposed to the right of publicity issue. Let's talk about what's going on in China and Jordan and their ongoing battles there.
Yes. So what happened was years and years ago, obviously, Michael Jordan was one of the first really, Muhammad Ali certainly, but Michael Jordan and Nike, right? He became an international superstar. I'm sure if you looked at the lists of the most recognizable people around the world, he'd be pretty high on that list. And so China now is a huge NBA market, right? And I remember, Dwayne Wade has the Li Ning endorsement,
right?
And there are other, athletes that have endorsements specific to Chinese brands. But what happened way back when is that when Jordan was getting to be very, very prominent and being recognized internationally, a Chinese company, I'm going to probably butcher this, Qiaodan, which I believe is the Chinese translation of Michael Jordan's name, essentially started building up this company, registering Chinese trademarks. And at the time, I don't think he noticed it. I don't think he knew that he had to enforce it. This company grew and grew and grew until it's a major athletic brand in China. And so what happened eventually is, Michael Jordan got wise to it, and I think in 2012 was when he initiated the lawsuit to have certain rights and certain specific trademarks. So let me just give one kind of quick tutorial.
Right.
China is a super important jurisdiction if you're selling there, obviously, but also if you're manufacturing there. It's kind of important to have registrations. We encounter situations all the time where our clients manufacture stuff in China, and Chinese companies that are manufacturing for them will go out the back door and sell their products, right? But also they will go and they will register our clients' marks in China. And then sometimes we're like, hey, Chinese manufacturer, why exactly do you have this trademark?
Yeah.
And they'll feed some BS about, we need this to export the products or anything. No, they just did this to potentially squat on stuff that they're producing for us in case they want to turn around and sell it in China. So what happened here was, so if you're trying to pursue protection in China from a trademark perspective, you potentially don't want to just register the rights in your Roman, Roman character trademark, right? That we're we're speaking, we're writing out to each other.
Mm-hmm.
You're also potentially wanting to register a Chinese trademark in the Chinese transliteration and I believe the Chinese translation, right? So it's, saying Michael Jordan, right? The transliteration, and then also if you translate Michael Jordan, those English characters, Roman characters into Chinese characters. So you're potentially looking at 3 different registrations if you want to fully cover your bases, possibly more because of the different offshoots and different dialects in China. So what happened is Michael Jordan went after certain registrations that Qiaodian had and wanted to have his own rights, wanted to cancel them. He wanted to have the ownership of his own name.
Oh, for sure.
Right,
yeah.
in the Chinese transliteration and pinyin.
Especially with a big market like that.
Yes. And so what happened is it went all the way up to the highest Chinese court at the end of 2016, I think early 2017. And it was kind of a mixed victory. It was reported a lot in the U.S. press as Michael Jordan wins the rights to his name.
Well, that's what I read, yeah.
But no, that was not the case, right? He only challenged specific marks that he could challenge because they were less than 5 years old. In U.S. law, there's kind of, if you have registration, you get what can be called, if you file the proper documents, incontestability after 5 years registration. And there's a similar concept in Chinese law, which kind of limits your ability to challenge registrations. And so the bird had flown the coop on a ton of registrations owned by this company. There's nothing Michael Jordan can do about it. But some of the more recent ones were the ones that he challenged.
Okay.
And those were the ones that the Chinese court, in a pretty large, atypical decision that has, a big impact, said, okay, we're canceling these. You're the one who has the right to your name effectively in China. But a number of other ones Qiaodian got to keep and continue. Right. So he will not be able to ever prevent this company from using the Chinese equivalent of his name.
Wow.
Because frankly, he just, didn't move too fast.
Wow.
And how would he know necessarily? I mean, we do some work actually still for managing his international trademark portfolio, but it's just, how do you necessarily know? And,
That's crazy.
The amount of money they have to expend to be enforcing all over the world and looking for the different types of things that you have to protect, it just can be very, very expensive, even for someone who has pretty large resources.
That's crazy.
And it's just the opportunity fled.
And that kind of harkens back what we were just talking about a few minutes ago about, when I talked to you about what can a smaller company do in terms of protecting themselves internationally. But even a bigger company are unable to, win all the battles with all the resources that they have.
No, not necessarily, right? Okay. The lay of the land, legally, time limits, as frustrating as that could be.
Right.
Which there's always a reason for them in the law. Mm-hmm. You don't want to, invest all this money in something and then, 10 years down the road, someone who could have challenged you earlier pops out of nowhere and then all that investment goes to naught. Yeah. Right? I mean, Qiaodian had obviously invested significant resources building itself up to a gigantic company. You can't just turn around and say, you have to change your name, right? That's like murdering it effectively,
True,
right?
Yeah.
All that goodwill would just disappear. Yeah.
Okay. All right. So, and final type of Michael Jordan. This is more of a right publicity case. This case, I get a chuckle out of it every time I read it. So in 2009, Michael Jordan, was inducted to the Hall of Fame. And, there was a supermarket or a store called Safeway that put an ad in a Sports Illustrated commemorative issue where you could rip a page out to get a discount for some of their foods or products in there. Now, Michael Jordan found out about this and sued them and won an award for $8.9 million. Now, essentially, that put that company out of business, but they were teetering anyway. But but what was funny here was that the commemorative issue that the ad that they put in to put commemorative issue, no one really took the discounts out because no one wants to rip a piece out of a commemorative piece of page out of commemorative issue. So it's really, really funny. But
they got slaughtered.
Yeah. I don't know whose idea was that because, I have a couple of commemorative issues for Sports Illustrated and I keep that stuff intact.
And anytime the Spurs won a championship, I'm randomly a Spurs fan despite being in New York.
Okay.
I kept all of those.
Oh, wow. Okay. So you kept the 1991 too, right? That's
the reason why. It was David Robinson. There's a famous photo of my family of me on my 8th birthday, holding up like a signed photo of David Robinson my parents gave me as a present with my gigantic gap between my front teeth before I got my braces on. But that's when it started, because basically I was like, this guy's Captain America. How do you not like this guy? He has super bright, good SAT scores, served in the Navy even after I think he was drafted. I mean, just the nicest guy ever, and that's how I got into the Spurs. And he was like just not also an a-hole, right?
Yeah, he's a great.
And then Tim Duncan was like this great spiritual successor. Yeah, also not a jerk. And then I thought Kawhi. Oh yeah, I can't. It's too. I guess too soon. I can't talk about Kawhi.
Yeah, I think that flew the coop. Yeah, but one of the interesting things about the Jordan case, what they really emphasized here was that this talks about managing your brand. Michael Jordan, as big of a brand that he is, he doesn't really associate himself with too many brands. There's a Jordan brand, there's Ballpark, Hanes. Mm-hmm. Is there anything else you know about besides from...
No. I mean, my brother-in-law actually is an agent that deals with this kind of stuff, right? Mm-hmm. So when you're talking about major, I remember reading somewhere, it came up in this case, Michael Jordan turned down an $80 million deal.
Exactly.
And so when he has that much money, these guys have the liberty of turning down $80 million if they want, but they control their own brand. The concept behind the right of publicity is if you can make money off of your name, your likeness, right, you should be able to control that. Someone else should not be able to profit off your name. Now, there's certain protections built in. So, I talked about the different fields of IP. I didn't include right of publicity. Right of publicity is kind of its own thing. And one thing about right publicity that's important is that there's no federal law that governs it, really, right? More than anything, it's governed by state laws. And as you would expect, certain states have stronger laws than not. And one of the states is California, obviously, with all the famous people there. And then I think that one of the other states that's important is Indiana, because there's like one company there that owns the rights to the estates of a lot of dead celebrities, like prominent people.
What?
And they've in that specific state, they've lobbied for really good right of publicity law. I'm fairly certain it's Indiana. And so, you control, if you can monetize yourself, you should be able to profit from it. And so here Jordan said, you're trying to profit off of me. They hadn't actually really profited.
Not at all. They actually went out of business right after that. That was the final nail in the coffin.
And they got crushed by this decision. I don't know ultimately. Yeah, I mean, with them going out of business, I don't know if they went to bankruptcy to avoid paying anything, but they got completely slaughtered on this case. And he's very, very litigious. He has, his name is extremely valuable. Yeah. So he has the resources to fight anyone who touches it, whether it's here or China or anywhere else around the world.
Yeah, I mean, that's one of the key things in order to protect your IP is really, really enforce it. All right. Well, how about John give a final tip, a final sign off in terms of IP law and protection to the audience? And
what I'd say is, if you're starting a business, the earlier you could get educated about this stuff, the better. I'm always happy to hop on the phone with people, no charge or anything, and just educate them, and build up goodwill. If they come down something later on the road that I could help them with, I help them. But I would say, like I referred to earlier, educate yourself early about the different types of IP protection and how they would relate to your specific business. And keep in mind that a little bit of money spent up front could potentially make you money later in enforcement, but also save you a lot of money and protect your brand before you lose the opportunity to. So I guess there's also a little plug. Like I said, Gottlieb, Brackman & Reisman is my firm.
Absolutely.
Our website is grr.com. My specific email is jpuro, J-P as in Peter, U-R-O-W at grr.com. grr.com, and our number is 212-684-3900.
All right, thanks so much. I'll post that information on most of our social media platforms. So thank you so much, John, for joining us. This has been a really good show. Thanks for listening in here. And this is part 1 of episode 1 of Hot Law Podcast. Get ready for part two coming up soon. Thanks for joining us.